state your full name and date of birth for the record for me? Miss Boone is seated at council table wearing a dark gray suit and a yellow blouse. She is in custody, however, she for the purposes of the trial based on the court's prior findings. We're here to conclude.
You have the right to remain silent. Anything you say and can will be used against you in the court of law. You have the right to talk to a lawyer and have the present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questionings if you wish. All right. You good,
dude? Good morning, good morning. October 17th, here we are. Thought it was going to be, let me turn the music down a little bit. Thought it was going to be a different type of hearing this morning, but it looks like it's the motions hearing. Let's get right into it. I don't want to get too far behind here. This is for Sarah Boone and the suitcase trial. Down just a bit here. They've already been started for a second, and I was on pause. So, girl, who are you waving at? You don't have any friends? They said no makeup, but I swear she looks like she has mascara on. She looks like she has makeup on. Her eyes, at least. You're way too happy for somebody who is on trial for putting your boyfriend in a suitcase. Move it, girl. Let's move it. Yep, here we go.
William Shea for the state.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? Ms. Boone is seated at council table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday on the website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions of the mayor and the case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
This is the first time I've noticed. It looked like she had like 5 people sitting behind her.
Okay. Madam Clerk has advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we
It's very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Get on the microphone or something. Everybody can understand what you're saying.
State?
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay. Correct. That's correct. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Clerk, Madam Court Reporter can provide a rough draft of what was ordered yesterday. We could go over it and review it, and make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with the motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay.
This poor
All right.
judge.
Madam Court Reporter, how long do you think it would take you?
This poor judge.
Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Ms. Rowans?
Snack time already.
How long do you think? 10, 15, 20? Okay, great. All right. We'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
My goodness. She's so proud of herself. She's messing with every paper on that desk like it's hers. Like she doesn't have lawyers. She has such a control issue. Would have been better if she just took the plea. What did they say? 10 or 15 minutes? They haven't started with Leilani Simon yet this morning. They're in court. It's coming up. The state's still scheduled to continue on their side this morning. It's going to be the fourth day, and I haven't had a chance to review any of the trial whatsoever, except for the first hour and a half of the opening statements that we went through on the other live. But other than that, I haven't had a chance. What other trial is on right now? Nothing this early. Oh, Melody Ferris. The docket is streaming their case. It's for the attorney husband, Gary Ferris. Snack time already. They'll be back in about 10 or 15 minutes. Let's go over this for now. Get a little review here going.
Let's turn to our top story this morning. As Sarah Boone's going to be back in court next Monday after jury selection was delayed due to Hurricane Milton. Court TV's Kelly Craft is in Orlando with the latest.
Good morning, Julie. The murder trial for Sarah Boone, the woman accused of suffocating her boyfriend in a suitcase, is delayed yet again, this time because of a hurricane. The mayor of Orlando has declared a state of emergency. The judge addressed the court this morning.
Due to the potential storm and the ramifications of it, the court is going to postpone jury selection in this matter till Monday, October 14th at 9 a.m.
Jurors were sent home and told to return on Monday. Another big development in this case, Sarah Boone has rejected a plea offer from the state. Let's listen to the judge discuss this with her.
15 years to a lesser included charge of manslaughter.
Ma'am, understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
Reject. But she should have accepted it. She wouldn't have put everybody through this trial. And I don't know. Maybe when all you have to look forward to is getting out and asking for snacks. Once this whole thing is over, she's going to be bored.
Reject.
And you heard Sarah Boone there rejecting that plea offer in which she would serve 15 years behind bars, pleading guilty to manslaughter. But now the trial will proceed on Monday, barring any other unforeseen circumstances. Julie, that's the latest from here in Orlando. Back to you.
All right.
Sarah Boone is a whole big unforeseen circumstance.
Our thanks to Kelly Craft for that update. Now let's dig in some more because we got some other news. on Monday. Not just the delay of the trial, but a motion filed by the prosecution. They are still trying to stop Sarah Boone from entering in that battered spouse syndrome defense as part of an overall self-defense, affirmative defense case. Let's bring in our guest now, the Director of Prosecution Projects at Florida International University and former homicide prosecutor Melba Pearson, and Court TV digital producer, and we like to say our resident expert on the Sarah Boone case, Lauren Silver. Good morning to you, ladies. All right, Lauren, would you start us off? You saw this motion hit the docket on Monday. You dug through it, the sum and substance of it. Would you kind of walk us through what the state is saying, please?
So I don't know that there was any case or any cause whatsoever for battered spouse defense, considering what she told everybody in her interrogation. I digress.
The large part of it is that the state is requesting that the judge to review the use of battered spouse, and also perhaps because the judge has already said that battered spouse can come in as a defense, say, well, at least Sarah will have to take this stand to set some foundation before introducing any kind of evidence, any kind of past bad acts. What's really interesting about this motion is it was written after the state deposed the expert for Sarah Boone. These are the forensic psychologists who are going to testify to battered spouse. And so we're learning a lot more about what she said happened that night, allegedly to the doctors, I would assume, including that she allegedly admitted to beating the suitcase with a baseball bat.
That was the first I heard yesterday. That was the first time I had heard them use the mention of the baseball bat. I had no idea. Repulsive. Absolutely repulsive.
That once George was inside of it, which is not something we knew before.
Right, Lauren, right. Let's talk more about some of these details. So I understand that he was able to poke his fingers out of a little opening in the zipper, and she is said to have hit his hand with a wooden bat in the house.
Oh my gosh, I did not hear that.
So apparently he chose to get in the suitcase. Again, this was a game of hide and seek. The prosecutors did suggest that perhaps Sarah misunderstood the rules of hide and seek, but he got into the suitcase. She helped zip him in. He had these fingers that were able to stick out. And at some point, he began to complain that he couldn't breathe. And this enraged her because prosecutors say it reminded her of when she felt she couldn't breathe because of his behaviors. And so she flipped the suitcase over, and then she hit his hands in the suitcase with a baseball bat.
Jeez.
Wow. Lauren, this is brand new information in that motion. How about it? It's been since 2020 we've been talking about this case. The other thing in that motion we learned is the victim was only 103 pounds.
Little bitty tiny guy.
How could he get inside the suitcase? That's the question I probably get the most from people, because you think, how could a man fit in a suitcase? I have no idea. Didn't see him get in. He was very small, 103 pounds. Okay, so prosecutors are arguing
Sarah probably wouldn't let him eat.
As a matter of law.
She's sitting in court waiting for her snacks, but she probably wouldn't let George eat. Narcissistic as she is.
What Sarah Boone told the doctors who evaluated her doesn't entitle her to get this evidence in, evidence of the prior violence, evidence that she was afraid of him, all of that. Melba Pearson, let's talk about this legally. The judge gets presented with this. Now he's got some more time to consider it, as you know, because of Hurricane Milton. Tell me, how do you think the court should assess this motion?
Yeah, so good morning, Julie and Lauren. And this is a very tough situation because you don't want to have, the judge doesn't want to make a decision that's going to end up being appealable once, let's say, a conviction is attained in this case, if he makes the wrong decision.
Speaking of appeal, a possibility of appeal. Apparently yesterday, like I said, I haven't got through the Leilani Simon case. We're going to do that and go back through it. The only thing I've gotten through is the opening statement. But apparently, one of the jurors fell asleep during the trial so far. 4 days in. Today is the fourth day. So either the second or third day, one of the jurors apparently fell asleep during the trial already.
and excludes that evidence, then that could be grounds for an overturning of the conviction at the appellate level if there's a conviction. However, there has to be something to substantiate these claims. She can't just say battered spouse syndrome and there is no documentation, there's no witnesses, there's no hospital records, something to document that she had been abused in the past. And usually when it comes to battered spouse syndrome, it's a matter of you got triggered by something the person did. It does not necessarily have to be the person beat me in this instant and I responded in kind, and that was and then I'm using the defense of battered spouse syndrome. That's one scenario, but that's not the only scenario. It could be a word track. So let's say, despite the victim being 103 pounds, giving the defendant the benefit of the doubt, which I'm not saying I believe her story, but giving her the benefit of the doubt, it is possible for a smaller man to be abusive to a larger person.
Oh, absolutely.
Just because of the dynamics of domestic violence, right?
Absolutely.
So, the size alone isn't necessarily going to be the issue. But again, the way that she went about it, this was luring him as part of a game
And
into
taunting.
a suitcase, and then not letting him out, filming it, torturing him, beating him. None of that is consistent with how most people react under the context of the battered spouse syndrome. So,
and then hitting him with the bat while he's in there telling you he can't breathe. We got just the one video. They obviously didn't record herself beating the hell out of him with a bat. Oh my goodness.
The extra steps she took looked more like torture than I was in fear for my life, therefore I reacted in this manner, as well as the statement she made to
She's
law
too
enforcement, where she was
narcissistic
like,
to be
it's a
scared of
game. I
anything.
can't believe, oh my gosh, not, oh my gosh, I was afraid he was going to hurt me, therefore I had to act in this manner. So I think there's going to be some very clear guardrails that the judge is going to put in place, and she's not going to be able to present a treasure trove of evidence around the battered spouse syndrome. That's not going to happen.
Right. Such a great legal explainer for us, Melba. Thank you for all of that. I want to share a clip. You both saw this when Sarah Boone decided to testify at her suppression hearing. And she let it out that she was still intoxicated at the time of that interview. I think the logic was that she wanted to make it seem, she was under duress, coerced, not in the right frame of mind. But this might also affect the defense. Melba, I want to come to you on the other side.
I think she was still drunk. I was still drunk.
I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on.
Traumatized by the situation that I caused, trying to focus on the fact that I probably had a hangover, woke up, and he was still in the suitcase. I think you even told the people in the interrogation, which I'm sure will come across in court, that you didn't believe that you were drunk. And then now you're speaking for yourself and trying to get your words out there, and you tripped over your own feet for your own defense.
At my home, I was hungover. I was still, I believe, intoxicated to a degree.
Okay, so Melba, you've already taught us that. So when we think about battered spouse syndrome coming in Florida, we're thinking about a self-defense case where the decedent would be doing something to threaten or, as you said, cause something to be triggered in the victim where they would, oh my gosh, feel the need to defend themselves. Here, this is an accident. So the state is saying, look, you can't assert it here. This was accidental. You've said it was accidental before. How does the intoxication get woven into this picture, Melba? Because she did make a lot of statements. And in the motion, the state is very concerned about her wanting to change her story. And Lauren, I'm going to come to you on that in a second.
It should have coached her better on what to say, but my guess is that she thinks she knows it all. And even if they had told her, keep your mouth shut or don't say this, that, or the other, I'm going to guess she's not going to care one way or the other. She's going to say what she wants to say. She's going to do what she wants to do. And she's definitely going to, in my opinion, she's definitely going to testify at her own trial.
The intox plays in for both sides, please.
I think the intoxication is going to be critical in terms of state of mind. Because again, it's not to say you can't be in fear when you're intoxicated, but the extra steps that she took and the way she behaved and the way she told the story afterwards definitely negates anything in terms of her being fear. And the prosecution is going to use that as in this was a drinking game. They both consensually entered into this. There was no abuse. And then she just went to the next level, became cruel, and she was the one abusive, not necessarily the victim.
Yeah, there was no way she, even if he was just 103 pounds, there's no way she could have physically put him in the suitcase herself and be intoxicated at the same time. Like, he literally would have had to agree to the situation because you're not going to even, I mean, you're going to stick a small child in a suitcase, even, you know, a 103-pound person is not going to just let you stick them in the suitcase. I can't think of any situation where they'd just be like, yes, yes, I will let you stick me in the suitcase. And no, I'm just surprised though, because she doesn't seem like the person who wouldn't have been vindictive. Like, he wouldn't know. He he's gonna have. I would think that he would have known her personality, and to get inside of that suitcase willingly, crazy.
Right, Melba, thank you for that. Lauren, would you remind us, please, the statements that Sarah Boone made? We know in this motion, the state kind of notes the ever-evolving stories, and they hint at, by the way, Judge, she's probably going to change it again when she testifies. Would you kind of take us back and refresh us?
She's
please?
definitely gonna change it again.
Yeah, I mean, when this started, this was an I don't know how this happened. I don't think he has a medical condition. This was just a game. I went to bed, and then it became well.
We
I
had a
never
good day.
imagined this could happen. This was clearly an accident, and I'll never drink again. I mean, how could this have happened? I never could have expected this. And when detectives pushed back on that, it quickly began to morph into a well. I mean, I was scared. What if I let him out? Then he could hurt me, which is a very different story than I went to bed and I thought he could get himself out.
Exactly.
It becomes an active decision rather than a passive one.
Right, Lauren. In the prosecution notes that in the motion, Melba's nodding. It's like there was a change, and you noted this as well legally, Melba. You know, at first it was a game, and then it became, oh, I'm mad. I don't want you to breathe. Just like I feel like I can't breathe when you cheat on me. You know, she's taunting him in the video, saying something to that effect. We'll leave it here for now, but this is something we're going to be watching as we'll see what the judge does.
Let's go check in and see if they've where we're sitting at here with this 10-minute, 15-minute, 10-minute intermission. That has definitely lasted a whole lot longer than 10 or 15 minutes. And even the chat slowed down. They've lost like 6,500 people out of the chat. There's somebody's head. Here we go. Here we go. Looks like we might be coming back to it. She's still shuffling those damn papers. She turns around like, pay attention. Oh, somebody in the chat just said that George would still be alive today if he had been carrying a pocket knife. I mean, how do you suppose he would have been able to wriggled his hand around to his pocket in order to... I don't know. I mean, I guess I have never been enclosed in a suitcase. I would be scared to death, especially if I couldn't breathe. I don't know how I would think I would wiggle my fingers around to get to the pocket knife that was just so conveniently in my pocket after a day of painting with Sarah Boone. And she needs to stop writing. Hasn't she already written enough? I mean, this is supposed to be emotion hearing for your snacks. Stop writing. We're tired of hearing your crap. Anything else cool come out today yet? It's only 9 o'clock in the morning here, so.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state. Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Well, that cures itself. Counselor?
Where
Thank
the
you.
heck
Record
were you,
reflect that
Mr. Beck?
has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure.
What was the question?
Madam Clerk's providing you a printed copy, sir.
Okay. So what just happened? I'm starting to think
Bless
everybody
you.
in this case is high maintenance. I bet this judge will be very happy to be out from under this case.
Have you had the opportunity to review that excerpt yet, Mr. Owens?
Of
All
course
right, go ahead and
not.
take a look at it.
Okay, I'll try not to be snide. He literally put the paper in front of her so she's snickering. Oh, this girl. And the chat says, I'm interested in the defense direction and in how they want to argue. Court in these cases is never straight closed on this decision. Sure thing. Case has been dragged out so long it's easy to forget things, and since it's so widely covered, I'll hear something and think that was on YouTube, or did that actually happen? Well, the good thing is right now we're going to go through the motions hearing, hopefully decipher through all of these things, then get the jury picked out, and then
All
the
right, Mr.
trial
J,
can
you
actually
may
get
proceed.
started.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984. Also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page. Florida 4th DCA, 1971. Reed, REID versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA, 2017. Rudin versus State, 182 Southern 3rd, 724 at page 726. Florida 1st DCA, 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony, to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts.
Right.
We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but
So the motion for her to get this battered spouse syndrome to fly in Florida, the legal defense of a battered spouse syndrome is typically going to be used in a case where the defendant claims that they were subjected to prolonged abuse and they're acting in basically a self-defense capacity when they're committing the violent act against their abuser. So the defense can be used to explain the psychological impact for the domestic violence and how it affects, the perceptions of the individual that was battered. So in order for her to establish the battered spouse syndrome in the state of Florida, you have to have certain grounds: a history of abuse, definitely an imminent threat, the reasonableness of the response, which means her response to the threat, it had to be reasonable, like proving that a violent act was the direct result of being scared to death of George, and it was necessary for her to have self-defense. And of course, expert testimony, which he just said, like a mental health professional, somebody like that, psychological, professional. And then the self-defense law. So in Florida, self-defense laws allow you to use force, including deadly force, if the person believes it's necessary to prevent death. So say, for example, she was so scared before she put him in the suitcase that something was going to happen. Before she started using deadly force on him, she was in fear of her life. If she reasonably believed that it was necessary to do what she did to prevent death or great bodily harm, then the battered spouse syndrome can be used to support her claim of self-defense. It's not a standalone defense, though, so it needs to be used as part of a self-defense claim. It's not going to just be able to be used by itself to justify her actions. Let's see what they say about it.
the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about full guy? Are we talking about opening statement? Or what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 7 2nd 750.
Interesting.
At
So
2.7.
in the context of the BSS or the battered spouse syndrome defense, there has to be a few, what he's saying is prior bad acts. So they have to have qualifiers. The battered spouse syndrome is not going to stand alone. So obviously you have to cite something like self-defense and previous bad acts. Anything like physical abuse, like anything like police reports or medical reports from before, witness testimony, and then that's the physical part. And then you have the emotional or psychological abuse. So like repeated verbal abuse, threats, intimidation, control tactics, which kind of leads me to believe she was the type. She was more of an aggressor of, of that perpetual behavior. But threats of serious harm or death, harassment, could be like somebody stalking you. These are all like qualifiers for something that would be, considered prior bad acts. And sexual abuse, obviously, qualifies. That's a qualifier. Um, like controlling your resources and isolation, like controlling your money, controlling the internet, controlling your phone, keeping you from being able to ask your family and friends, to help you, or being, coercive surveillance. So, like, qualify. All of these are just qualifiers for how the defense could possibly make sure that Sarah has a a chance in hell. She doesn't have a snowball's chance in hell. Not for this defense. She just doesn't.
60 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on particular occasions, section 90.40414 statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide.
So what he's stating is the admissibility of prior bad acts. In Florida, the admissibility of prior bad acts is governed by certain statutes from cases that they've had before. What he said was Florida statute section 9404-2, I think. I'm not sure. But it allows evidence of prior bad acts to help establish a pattern and a motive. Which, normally they don't have to establish motive, but it's, the relevance, the prior bad act has to be directly relevant to the defendant's claim. And then prejudice versus probative value. They have to balance the probative value of the evidence against the risk of unfair prejudice to the person who's being accused.
Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
So that type of evidence is going to strengthen the defense argument. And that the way that it does that is it paints a fuller picture of the relationship dynamics, and it always helps the jury by helping them understand a defendant's mental state leading up to the incident. So it helps justify self-defense argument because, like I said, you can't have a battered spouse syndrome argument as a standalone. So it'll seal the deal for the justification for a self-defense argument by showing that Sarah reasonably believed that there was danger due to a pattern of violent behavior. Does the defense have enough evidence for that? Do they have enough evidence to prove that she was so scared she had to do this to him? Good morning, everybody coming in. I really wish
Received and understood.
fix their
Any other
microphones.
clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
Your Honor, and then the only other thing that beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes of all the motions that were ruled upon yesterday at some point. For the record for the 60 state.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense. That is correct, and the court ruled specifically on that yesterday, and that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
It's not the overact. It's not the standalone. So then, if the defense is able to prove self-defense and battered spouse syndrome through the prior bad acts, then what the prosecution is going to have to do is, I think they're going to have to go along the lines of establishing maybe like a narcissistic personality trait, like grandiosity, her lack of empathy, manipulation, her gaslighting, um, psychological and emotional abuse on her part, blame shifting. It's just typical stuff like the denial, constant criticism. We know that she has an issue with devaluation. She does it to 9 lawyers before we get where we're at now. Triangulation. Narcissists usually use third parties like family and friends and family members and other romantic interests like ex-husbands to help manipulate or provoke jealousy, or to keep their partner emotionally off balance and reinforcing control. They use isolation for sure. So I don't know, we're going to have to see trauma bonding, cycle of abuse. I mean, there's just so much that they could use to prove their case against her saying that she was a battered spouse or self-defense.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to provide as the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume.
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
Good morning, everybody coming in.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
Please fix your mics,
One,
defense.
1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because.
Okay.
So now
this
you
morning,
object.
After having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding the treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision.
So we understand what happened, right? So basically the reason that they're having so much problem adjusting to this now is because at the motions hearing where he's just like, yeah, it's battered spouse syndrome. Didn't you know? And so they put a whole lot more in discovery. So this guy's having to scramble, which I think was probably intentional. This guy's having to scramble just to go through the motions hearing, much less try to get her through her trial.
Not objecting. This morning, I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down. They were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone.
So they're introducing new evidence.
That now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting, we are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this court,
So, just for clarification, a Richards hearing refers to the proceeding used to determine whether the prosecution has violated discovery rules. And they failed to disclose evidence to the defense, and it originates from Richardson versus State, which is what he was citing from the Florida case. So, in a criminal trial, both sides are required to share evidence that'll be used in the trial. It's called discovery, which most of us who watch true crime know that. If the defense believes the prosecution has failed to provide important evidence, they can request a Richardson hearing. So during the hearing, the court says whether the non-disclosure was intentional or if it was accidental, whether it harmed the defense's ability to prepare, and how it might affect the outcome of the case. In this case, it's going to ask the question, it'll beg the question, did it harm the prosecution's ability to prepare? And if the judge finds that the discovery violation impacts the prosecution's case, then they could, there's a lot of things they could do. On the defense side, it would be like up to even dismissing charges or granting a mistrial or excluding certain evidence. So if you're incorporating a Richardson hearing into one of your true crime cases, you definitely want to make sure you don't want to lean towards a mistrial before you ever get started with the jurors.
point in time, the court is going to proceed with a Richardson hearing. Defense?
I really wish I could hear what he's saying.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. The state had no objection to those. The state further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time. The 81 pages are not at issue.
So it's already clear that the defense counsel had already put in 81 pages of some kind of crap that they wanted to put into discovery, and then all of a sudden another 115 pictures show up out of the middle of nowhere. So basically the prosecution is saying, okay, we didn't object to the 81 pages from September 27th, but now it's October the 17th. We're supposed to be picking a jury. We're still in motions hearings right now. We're not picking our jury. And then you introduce another 115 pictures of turned around, upside down crap that we have to go through, which begs the question, the Richardson hearing begs the question of, did you violate the discovery and evidence? Does anybody read lips?
And what do the 119 pages evidence?
So we don't even know what's being introduced because we can't hear them. We have no idea what she just introduced.
I need more specifics than that.
The assumption is it's medical records.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she's in to coincide.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
It's obvious that they're different, because otherwise the state wouldn't have
Moreover,
a problem with
I
the
need to make a
introduction.
determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
We've seen this lawyer do nothing but scramble, and I'm not 100% certain. I've never looked into his past. I know nothing about him or I know he is working for her pro se, or not pro se, pro bono. And so she's, got a free lawyer, and he's trying to make a name for himself in a high profile case. And it's turning out badly.
When did you receive them last week? Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood. All right. I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed.
Okay. Yes. That's what's going to be offered into evidence at this point in time. Appreciate it.
If he's going to offer it into evidence, he
So
needs
with
to give it
regard
to the
the
prosecution.
state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving
I'm
now
so
to
frustrated.
item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had service on records. And I sent a request to various medical facilities asking for records.
I think this is done completely and 100% on purpose.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Boone. Once again, I'd spend my personal time reviewing these records.
Wow.
Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state
Why would they send that to
had
him?
great difficulty understanding what, if any, pages of these records are relevant.
Exactly. Why?
On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225.
So she sent 328 pages of complaints, and her gynecologist, oh Lord.
Goes through alcohol abuse, yes. Type, spirits, not wine. Last used 2/23/20, several times a week.
Convenient.
The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results. And we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sitting meeting over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, in her deposition. The anxiety she may be suffering from at jail was from being in the jail. So there are questions about that. But generally, you get these records, as you know.
None of these records have any relevance whatsoever to the battered spouse syndrome.
What is the relevance
The
of
self-defense.
these records?
There's none.
What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And we took her deposition the 1st and 2nd. So this is also a problem, even if it's just going to be relied upon, not introduced. And I appreciate them letting us know that they don't seek to introduce these records as evidence. Because, of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's being relied upon. But how are these records relied upon if they acquired them after we've done all the depositions?
Exactly. They're brand new.
Dr. Harper did say that she relied upon some jail records during her deposition. The state didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Jerome? So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will think about that position. So I'll wait. I will not ask her to review.
Okay. State with.
That was the only purpose.
Okay. So state understanding that tactical decision and that Ms. Dr. Harper is not reviewed and seemingly will not be relying upon these experts. Does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they're not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence itself, but the reports may be used to refresh the officer's memory.
Okay. Does that cure that understanding?
So
Okay,
maybe
all right.
used
So
just to
based on
refresh
Mr.
memory.
Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeated of 11.
So did you see that little snide, just little smile that she had? She thinks she considered that to be a win. It wasn't a win. It didn't win or lose. They're not going to use it for anything. They're not going to admit it into evidence. It's just for refresher purposes. I don't understand why she thinks that's a win.
So the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection? Response? Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
But we're referring to the prior record of
Okay.
I know he had some priors.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to?
So there's the confirmation she will testify. Which
What
we all knew
is this
she would.
oral testimony? Because this is an exhibit list, so that's my confusion. If it's oral testimony, that may be a different critter once the overt act is established under Holland.
How can they hear each other in court even? It's maddening. That is maddening.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position? Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems
Good
to
morning,
be
Matthew.
whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse.
LinkedIn. What?
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical. Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list. Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to
So he just
19,
withdraw that. Okay.
Orange
Golly.
County Sheriff's Office investigative workup report. Response. Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation.
So it looks like they might have got a little scared about the Richardson hearing and whether that was going to cause an issue with the discovery rules. And so they've backed off and now they're saying, okay, let's just withdraw that. Oh, no, we don't need to put that in there. Oh, no, that's just for refresher purposes. No, don't worry about it, Judge.
The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong. I color-coded this and I miscolor-coded this one. Okay. Then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument. Okay. I'm going to overrule the objection as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is.
Okay, so he's using really big words. So it seems like he was talking about a declination of prosecution. And that refers to the decision made by a prosecutor not to pursue criminal charges in a case. So when a prosecutor when he issues a declination, it basically means that they've reviewed the evidence and the circumstances of the case, but they've decided not to file charges or bring the case to trial. And that can be various reasons for that, like insufficient evidence, mostly. The belief that if you charge somebody for it, it's not in the interest of justice. Like if it's a minor or accused, if the person who's being accused has no prior record, if the victim doesn't want to proceed, the prosecutor's office might also prioritize that case with more severe crimes. So you just have to get more detail on how that works for your specific case or the context. So basically it's a reference to a decision made by the prosecutor not to pursue criminal charges in a case. So I don't know if there were additional charges that they could have pursued and they chose not to.
Placed into evidence. Moving to 22, family law case file, Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection is to relevance and hearsay. Response?
So before they get too far in this, the Boone v. Boone refers to a family law case in Florida from way back that involved issues over divorce. But I'm going to guess for Sarah Boone's categorically, it's going to be over alimony, property division. But without a specific year in the case number, it's hard to pinpoint which one. I think he said 2017, but these cases usually focus on how Florida resolves family law disputes. That's what Boone v. Boone usually refers to. Alimony guidelines and whichever's in the best interest of your child. See, yeah, he's talking about custody. It was not the agreement they originally had in order to pay out home litigation, going on trying to test counsel. I don't know.
What does the non-payment of alimony
Yeah, okay, so alimony
have to do with what's happening in a family case?
Well, that judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached. That her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid out $50,000 a month for a number of years,
I don't understand how the distribution of assets, child custody, or alimony could have anything to do, or property division could have anything to do with this.
Ongoing pending litigation that has not been decided by a circuit court judge in the 1960s family division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. It sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is...
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, under cross-examination...
But it sounds like there's pending litigation, including a relocation or, and I don't know because it's not my case, I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court.
Please tell me, for God's sake, Sarah Boone, that you are not worried about your alimony behind bars, like you don't have enough commissary and you couldn't get enough snacks or Pop-Tarts or juice boxes to go through court. And that's why you're mad about your alimony while you're sitting behind jail, going through this trial with all these motions hearings and all this crap you're doing. Miss me.
Court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
This is some of the most ridiculous testimony I've heard in a motion hearing ever. This is ridiculous. She's been sitting there since 2020. How are you still writing? Somebody take that pen away from her. And those people that are behind her are struggling to figure out what they're going to do about this other part of this Richardson hearing that they're going to have to circle back around to. And they're back there freaking out because they don't want to, they don't want to have an issue with discovery and evidence that hasn't been ruled on yet. So they're having to stand back there and work their butts off trying to figure out why they admitted some of this stuff into discovery. If I just don't. It's usually the defense that believes the prosecution failed to provide the evidence, and now we're completely backwards. It's not unheard of, but we're just completely backwards. Hi, Daniel. You didn't miss anything important. Basically, she's just messing with the court's time. So far, the motions that have come in have just been basically based on the new legal defense of the battered spouse syndrome. And we just talked about how that is not a standalone defense. So she's going to have to introduce self-defense into that. And so basically, for her to stand on that, she's going to have to find a whole bunch of ways. Her defense lawyer is going to have to find a whole bunch of things to introduce, like the history of abuse. Right now, they're going through prior incidences that George may have had that would have caused her to believe she was in imminent danger, or she had a reason to respond, and put him in a suitcase, beat him with a bat, throw him down the stairs, roll him over a couple of times, and then record it while he couldn't breathe. So according to her and the defense that they're setting up, and what she's going to testify to, is that she was drunk. No, does not. Not a chance. Not a snowball's chance in hell. And I'm also irritated at the fact that I see makeup on her face, and I know that the judge ruled that she was not supposed to have the makeup. I'm a little irritated at that. I know that's petty. It's irritating. If she goes back into the jail with that mascara on her face, and she's in, and now I don't know whether she's segregated or not. I make the assumption that she is, because it's such a high profile case. But if they see her with all that makeup on and cite favoritism, it could be an issue. She could get beat up. So, okay, so like I was saying before, the prior bad acts that have to kind of qualify. So George will have had shown physical abuse to her, emotional, psychological abuse, sexual abuse, threats of violence. They're going to have a whole bunch of defenses for this to work. No, she's with others based on. Oh, okay. That's good to know. Well, then maybe she will get beat up for her mascara. I'm sorry, I'm kidding. I don't wish her to get beat up. I wish they could move on to the jury selection so we could start a trial. It's been long enough. She's wasting all of your taxpayer dollars. So when they circle back to the Richardson hearing is just going to determine whether there was any violation in the discovery rules. So we've got to reach some kind of decision on that before the end of the day. And then the declination of prosecution, which is what they're discussing now, refers to a case that hasn't been ruled on yet. So basically, she's talking about the Boone v. Boone family case, where the divorce, child custody, alimony, property division, all that kind of stuff is still up in
Thank
some
you all
law.
both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Based on counsel's representation,
25 motions.
To utilize the court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any other 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No,
I
not that I know of.
haven't seen it either.
We
I want to
not
see
received
that.
it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. The court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the rule?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
The objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection. State any response.
So I'm not going to insult anybody at all, but basically sustaining on stipulation, that basically refers to the legal situation where the court agrees or sustains an objection or a legal matter based on a stipulation made by both parties in the case. So stipulation is basically a mutual agreement between both parties in certain facts or issues. So in this context, if an objection or motion is sustained on stipulation, it means the judge has upheld it because both sides have already agreed to certain terms or facts. So they don't have to argue about it anymore.
Any and all exhibits previously listed by the state?
Mm-hmm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limited to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense, that tied in with the self-defense. And so practically he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it.
Well, if you have met Sarah Boone, there is a reason that people have to try to control the situation and get her to shut her mouth.
She's going to testify in trial about it. It's not my fault that he felt like he got an answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder.
So if we're being factual, the Sixth Amendment to the United States Constitution is part of the Bill of Rights, and it guarantees that it's the rights to the individuals that are accused of crimes. So it ensures that all the defendants receive a fair trial. The right to a speedy trial, right to a public trial, right to an impartial jury, right to be informed of her charges. She knows what she's charged with. The right to confront your witnesses, the right to compulsory process, and the right to counsel. I don't see the Sixth Amendment, it's crucial that we protect the rights of our defendants, and I understand that, and to get a fair legal process. But if you're looking into a specific part of the Sixth Amendment that's violated, I can guarantee you she knows what she's charged with.
So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second.
So basically, they're asking for a crystal ball, and so what is going to be presented? They want to know what's going to be presented. Nobody's going to know that until you guys start an actual trial. Stop with the frivolous motions, get your jury picked, and move on.
Second-degree murder. So, in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew. They've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense.
So, in order to get an indictment for second-degree murder, it generally requires certain elements to be present, right? It's normal, reflecting legal standards that the law of the state that you reside in is already set forth. Okay. The specifics are intent. Did she act with the intent to kill or cause serious bodily harm? Malice aforethought, which means the act was done with a reckless disregard for human life. Causation, which is the defendant's actions directly caused the victim's death. Circumstances of the crime, the specific circumstances under which the killing occurred can influence whether the charge is justified as second-degree murder. And it's in factors like, was it committed during the act of a felony? Did it involve a weapon, maybe a bat, and a suitcase? Whether there are any mitigating circumstances. And then jurisdictional requirements, which is basically, it would say with the procedural rule of the jurisdiction in which the crime was committed, like it was in Florida. It's usually the state laws about how indictments are issued. So in most jurisdictions, an indictment is formally issued to a grand jury after they have all of the evidence that they need and that's been presented to the prosecution. The grand jury's role is to make sure there's sufficient evidence to formally charge a defendant with a crime before they put them in jail.
And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Why does he sound like Sarah?
In response, Mr. J.
Yes, sir.
These are all of the arguments that I expected to hear come out of Sarah Boone's mouth when she was representing herself pro se. I'm not sure where the argument lies on this. I mean, the lawyer is not dumb. What are you doing?
Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence.
So they sat together on the first week of October at the rules of procedure, which basically is the guideline and a standard that the courts go through outside of everything. That it's like a process that you go through. You sit down, the rules ensure that the legal proceedings are going to be fair and efficient. So basically you're outlining your steps and your protocols for your different things, like your civil procedure, the criminal procedure, the evidence rules, the appellate procedure, the family law procedure, administrative procedure. It's all of these things. It's like a purpose. The purpose of the rules of procedure is for fairness, efficiency, and consistency. So you want to make sure that all the parties have the fair opportunity to present their case. The efficiency will streamline the legal process so you can avoid unnecessary delays. Sarah Boone. The consistency provides like a uniform framework for the legal proceedings, promoting predictability and outcomes, which is basically what he's arguing here. Well, we had to show our hand and we were forced to do that. No, you were not forced to do that. It's normal for a federal rules of civil procedure to take place. It addresses the defense objections, the prosecution's objections. Rule 26, it covers the discovery process. So all of the discovery was made known, and now you're introducing new stuff, and so that's why we're in a motions hearing. And then Rule 56 basically is the summary of judgment, and it allows a party to seek a ruling without a full trial if they didn't have any, interest in going to trial after they've already sat down and gone through the rules of procedure. But this is ridiculous.
I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case.
Okay, so that is in reference to their request for a renewed request for statement of particulars, which basically it involves one of the two parties requesting the detailed information or clarification about the claims or the asserted, the defense is being asserted by the opposing party. So basically, its statement of particulars is a document that gives the specific details about all the claims or defenses in a lawsuit. It helps the parties understand the stakes, basically. Yeah, exactly. That's exactly
That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case.
Okay, and then that's where purpose comes in. So that's where they're giving clarity and telling about their preparation and their efficiency. It streamlines the litigation process so you don't have all of these ambiguities.
The medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
So basically, he's talking about where they're having the pleadings. If they were too vague or overly broad, they could probably be compelled to do what he just did, was give a renewed statement of particulars. There's no reason to go back and write it down and go through a whole nother hearing or waste any time. He just told you what their case was. You did this. You recorded that. The man is dead. Let's go to trial.
Any rebuttal?
I wanted that in writing.
See what I mean? See what I mean? Why do you need that in writing? He just told you what the case was. And in Florida, now I'm pretty sure there's a court reporter out there somewhere. Request it. Get a grip, dude.
She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state that through.
It wasn't a rebuttal. That was their case.
That Mr. J just gave about her testimony, I do not agree with.
Which is why you need to go to trial so that you can tell everybody why you don't agree with it. Because the judge has no bearing on whether or not she's going to get life in prison or not, or whether she's going to get charged with second-degree murder or not. That's what you have to go through. Select a jury, hear the defense's side, hear the prosecution's side, and let it be. What is this guy trying to do?
There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone.
Why are we testifying about what? Why are we testifying about of hearing that little case so you guys can get through the procedure, make sure that your civil rights weren't violated? It's just a rules of procedure. You're not testifying during the rules of procedure. Everybody in that room knows what was said. Everybody in that room are trusted people. You know what you said.
We just dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and the doctor. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for.
Exactly. So move it along.
I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It's something I was asking for a couple of weeks ago.
The grand jury indicted her. Y'all have known since 2020 that she was indicted for second-degree murder and all of the things that she did. Everybody has seen the suitcase video. Everybody has seen the interrogation video. Everybody has seen the arrest video, and everybody's heard the 911 calls. You know what she's charged with. You're up against the worst defense. You don't have a defense. That's the problem.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. I just want to make sure they meant to overrule that.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. Well, if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of the witnesses they listed.
I believe those are the same witnesses that they've listed in regards to the prior incidents. The deputies that went out on the call outs and cases that resulted in cases that the state attorney's office and 911 dispatch.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
We don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining.
Yes, you are.
As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not call many of those that she wants to. I believe my right to do that, to present our defense with our witnesses, is paramount. She does not have to.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Snack time, snack time. Go get your juice box, girl. And your Pop-Tart. Go wipe that makeup off. You ain't allowed to have that. She looks a little worried. I can't say that I blame her. Said brief recess. Did they say how long they were taking? I didn't hear them say how long. You can usually count on it. If it says 15 minutes, take 30. So this particular case, which everybody already knows, she was charged with the murder of her boyfriend, George, in 2020. So the case gained notoriety because of the unusual circumstances, right? So it took place in the apartment. Some key points or overview on the case. There was an incident. She put him inside a suitcase, or he got inside of the suitcase himself. During a heated argument, after he was already in the suitcase, she left him in there for hours, God knows how long. When she opened up the suitcase in the morning, she found he was unresponsive. So the charges, second-degree murder, the prosecution's arguing that she acted with malice and intent to kill George, while her defense is claiming that it was an accident. And now they're using the defense of battered spouse syndrome. And they cannot use that and stand alone on that. So they're going to have to use it in conjunction. It's not a standalone defense. Have to use it in conjunction with self-defense. The key evidence that they have so far that we know of is the evidence from the scene, the interactions that led up to the incident that might provide a little bit of insight to what happened. And then witness testimony, friends and family regarding the relationship that she may or may not have had with Torres. So he was just now talking about what kind of witnesses they're going to call or may not call. She may want 50 witnesses called, and the defense may only call 10 or 2. They may call none. The current developments, which is what we're in here doing today, is hearing the motion hearing. And the legal case has gone through, I don't know how many court hearings, the discussions about her mental state, her request for snacks while in court, which attracted a lot of attention this last week. I've made a short on it. I do not regret it. It was funny. Um, and then the public interest. It's the case that's captured public attention because it's bizarre, right? It's it's serious. It has serious implications. The charges are serious, but it's bizarre. And it doesn't I don't know anybody that would allow me to put them in a suitcase during hide and seek, because the idea of hide and seek, right, is for you to hide and I will seek you out. But if I know where you are and I zip you up and go, okay, this is going to be fun. I just put you in a suitcase because you're 103 pounds and I'm going to zip you up in there. Like, how fun could that be? And that everybody was laughing and happy after a good day of wine and art. It's just not a thing. It's just not a thing. So we'll have to see. They've already confirmed she's definitely going to testify at her own trial. We know that. It's probably going to be a real horse and pony show. The only way for this to work, for her to meet the grounds for the battered spouse syndrome in the state of Florida, is to get the history of abuse. So she has to show that there was evidence of some kind of physical, emotional, or psychological abuse that he inflicted on her. You can have that. You would give it to people through like testimony or medical records, police reports, witnesses. The abuse has to be an ongoing thing, not a one-time incident. A one-time incident does not constitute history of abuse, so it would not constitute battered spouse syndrome. The second part of that would be to demonstrate imminent threat, which means she has to prove that she believed she was in imminent danger of death or serious bodily harm at the time of the act. Not at the time she put him in the suitcase, because she's already stated we were having a good time. No big deal. It was a lot of fun. But she says after she put him in there, zipped it up, hit him with the bat, turned him over. He already said he couldn't breathe. Then she decided she was in imminent danger of death or serious bodily harm after she had already committed a few felonies and beat the hell out of the guy. The reasonableness of the response is basically her response to the perceived threat has to be considered reasonable. Not after she had already done something to him, after she's already beat the shit out of him, but was her response to him reasonable before she became scared because she had already screwed up and put him in the suitcase, left him in there, and he can't breathe. But now she's scared to let him out. But her response to reasonableness of the response before that happened is not going to fly. They could have expert testimony. They could have a mental health professional provide testimony to explain the psychological effects that battered spouse syndrome and how prolonged abuse can alter your mental state and your decision-making process. Alcohol was also introduced. And then you have the self-defense law. And in Florida, self-defense law allows the use of force, including deadly force, if the individual reasonably believes it's necessary to prevent their own death or great bodily harm to themselves. BSS is often used to support a claim of self-defense. Like I said, it's not standalone. You use it to support the claim of self-defense by showing that you were acting under extreme fear or duress during the act. So it's not a standalone defense. It has to be used as part of a self-defense claim so that you can justify your actions. The success of a defendant depends on the ability to show a pattern of abuse, not just a one-time thing. And it also it also is just not going to work. It's just not going to work. Time is it where you guys are at? It's barely 10:15 in the morning here. See if we can find anything else going on. Let's check in on the Leilani Simon trial. Let's see what's going on over there. This is the 4th day of trial for Leilani Simon. And the last time I checked in, they were Daniel was still testifying. Let's see what Court TV's got going on. Let's check in over here while we're waiting.
At 10:41, she said, "I'm about to turn on to 204. And I said, "Okay," at the same minute.
And what's the next message?
She said, "No," he said, "in a little bit."
What is that a reference to?
I believe it's in reference to Paul. I'm honestly not 100% sure.
And then your next message, maybe that'll clarify.
That's what I said. Oh yeah, I remember it. Sorry.
Can you first read the message and tell us what this particular part of the exchange means?
That's what I said, you said, he said. But he said something about no, it was I'm on the way or something.
Let me just ask you this, does this exchange refer to some sort of like miscommunication between the defendant and Paul about when exactly Paul was going to get out?
Yeah, that's what I'm gathering from it. Yes, sir.
And then at 10:44 at the top of page 7 of this document, what did you say?
Thank you for the little bit left. So sweet, no lie.
And what were you referring to here?
She left a little bit of Coke on the top of the dresser for me.
Was it in a bag or not in a bag?
Thanks, baby. I appreciate it.
I think it was a little line left out.
How much was it?
0.05 gram.
Was it the last? I'm going off of the text of the message here. Was it the last of what y'all had in the house at that point?
Yeah.
Okay. And did you use it?
Yes.
I think. Well, let me ask you this. Earlier, I think Mr. Hilliard may have asked you, were you drugging and drinking at that time? And I think you said no. Was that an intentional misrepresentation?
No, it was not.
Do you remember coming up to Savannah maybe a month or so ago and sitting down to talk to me in preparation for this trial?
Yes, sir.
And do you remember our going through all these messages together?
Yeah, I do now.
And do you remember my specifically asking you what that text message meant?
Yes, I do.
Do you remember freely admitting to me at that time?
Yes, I do.
Reference to a little bit of cocaine.
Yes, I do.
I feel like there's such a difference in the feel of this trial than in Sarah Boone's trial. The prosecution has such a finesse so far, and the defense has really kind of been kind of left with not much to say and not much to cross-examine because this is the second day he's testified. I have not caught up on this, but Sarah Boone was much more interesting this morning, only for purposes of my nerves. This one is a baby, a 20-month-old baby that was tossed out in he was tossed out into trash, and they found him in the landfill after he was, trigger warning, crushed over and over, and they found him already decomposed in a landfill and had to. It's just it's a sad case.
What if anything was holding you back from going to sleep at this point?
Her being back.
You know, scrolling down to the top of page 8,
6 minutes later,
what did you say to her?
or not.
Has she responded to your last message about come
No.
back so we can crash together?
No.
So you say or not, and what does she say?
I love you.
And what does she say next?
And I'm about to be walking to the car.
And what time was that message sent?
10:51.
In your response?
1 minute later, I said, oh, okay.
And your next message?
I guess I'm gonna eat this food and stay up for a few. So I guess I was sleepy.
Do you know what food you were referring to?
But I believe it was the spaghetti.
What were you doing at this point in time?
Laying down in the bed and trying to wait on her.
As far as you were concerned, was the day pretty much over at this point?
Yes, sir.
And what was your next message in Lynn?
10:56. I said, I no want to be tired or you be tired either. May.
And that was how long after the last message where you said, I guess I'm going to try to stay out for a few minutes?
4 minutes.
You're still wanting to go to bed at this point?
Absolutely.
Just wanting her to come home so you can do that?
Yes, sir.
How did she respond to that?
I know, maybe.
And what did you say?
I know you don't feel great. I don't know how you're still up. And I wanted to watch a movie. Sad moment.
And what time did you send that message?
1 minute later, exactly.
How are you feeling at this point?
Sad and tired.
Did she respond to that message?
No.
What's the next message?
4 minutes later, I said, moi.
What does that mean? I don't mean to embarrass you. I just don't know.
A
Who
kiss.
knows? All right. It's a text message representation of a kissing noise.
Yeah.
Okay. And when did you send that message?
4 minutes later.
What time of night?
11:01.
All right. 11:01 p.m. on the 4th.
Yes, sir.
Did she respond to that message immediately?
No, it was 9 minutes later.
The reciprocal discovery list. The court is going to reserve.
Oh, now I got to go back just a little bit because it looks like they started as soon as I went to go get a drink. Rude. Plus, I let it go a little bit so it has a little bit of closed caption since we're having such an issue with the microphone. Come on now. I didn't go back that far. What the heck's going on? I know I heard them. The poor people in the chat are like, this is dragging on and on. Everything Sarah Boone drags. And they're still going to do jury selection today. There we go. Looks like somebody's head's coming up here. There we go. She's still writing.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing, with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages.
It was for all the new pictures.
Advent Health, and they're a little bit different than the one paper that I previously used.
It was for all the mismatched pictures, Judge.
So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence, Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
Okay, response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, got a substitute analyst. So that's our reason for the late disclosure on her. Who were the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. We end up having to call them, then that's fine. We will pay for the expedited transcripts. But I would expect it not be lengthy.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever disclosed.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have that thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us.
So I didn't hear exactly why they said the original Florida Department of Law Enforcement person was not going to be there. Those are the people that are usually responsible for, like, the crime analysis, the criminal investigation, the forensic services. They're the ones who do, like, all the statistics and the reports and the crime mapping and all that kind of stuff. So I'm wondering what might have happened to the original FDLE person.
The juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
Pause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the order tennis motion, as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need
Denied.
to address, state, before we report back to
Snacks are
23
denied.
at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
My whole intention for 2 hours of my life today was for that one comment right there. Snacks denied. Sarah Boone, you eat your commissary in jail. Snacks denied. She does not look happy about that. She's going to be dehydrated, missing her juice. Okay, well, it looks like they're going to be in recess, so it looks like we should recess as well. Hopefully I don't know a whole lot about what time. They said they won something about coming back for jury, so maybe I'll get a chance to come back. I really, really appreciate everybody in chat today, and if you could just do me a favor, maybe hit the like or the dislike, subscribe if you want to. I'm looking forward to meeting each and every one of you and having these conversations more often. Everybody have a great rest of your afternoon.